courtroom held its breath as he leaned back, smug, certain victory was his. The judge's gavel hovered, ready to seal his triumph. But then she rose, calm yet fierce, and slid a file across the table. Silence fell, inside, a secret so explosive it could shatter everything. The air in the United States District Court for the Southern District of New York was a carefully engineered substance, a blend of recycled coolness, polished oak, and the low, imperceptible hum of a justice system in motion. It carried the scent of lemonwood polish and starched cotton, a smell of absolute order. Sunlight, filtered through the narrow, bulletproof windows, fell in sharp geometric patterns across the empty jury box, highlighting the federal seal embossed on the wall behind the bench. This was the theater of the modern American legal system, and its current drama, United States versus Ether Dynamics, was nearing its final, seemingly predictable act. For 7 weeks, the courtroom had been the battleground in a sprawling, complex corporate fraud case. The Department of Justice alleged that Ether Dynamics, a green energy titan with a soaring stock price and a charismatic CEO, had systematically inflated its revenue projections to investors by over $3 billion. It was a house of cards built on carbon credits and hype, as the lead prosecutor, David Chun, had thundered in his opening. But over the course of the trial, that house had proven frustratingly difficult to collapse. The defense, led by the silver-maned and devastatingly calm Clayton Price, had meticulously picked apart the government's case. Whistleblowers were recanted or revealed to have axes to grind, email chains showed plausible deniability, the complex financial models were argued to be optimistic, not criminal. The mood in the room had shifted. The press row, once abuzz with scandal, now typed quietly, their headlines shifting from fraud trial to prosecution's case falters. Now, in the silence of a bench trial where Judge Eleanor Vance alone would render the verdict, the conclusion felt foregone. Price sat with the serene posture of a man already mentally spending his victory retainer bonus. His client, Ether's former CFO Michael Thorne, allowed himself a small, tight smile as he adjusted the cufflink of his $2,000 suit. Across the aisle, David Chun stared at his legal pad, his jaw set, the weight of a failed career-making case settling on his shoulders. Judge Vance was a monument of judicial temperament. In her early 60s, with a steel-gray bob that never seemed to move and eyes the color of a winter sky, she was known for her preternatural calm, a brilliant legal mind, and a near-legendary impatience for grandstanding. She had presided over the trial with a terrifying efficiency, her questions sharp, surgical, and devoid of theater. As she gathered her final notes, the only sound was the rustle of heavy paper. The court reporter's fingers hovered over her stenograph machine. 2 deputy marshals by the doors stood at relaxed attention. The verdict was a formality now, a piece of legal logic about to be stamped onto the record. The narrative was set, the government had overreached. Judge Vance lifted her chin, preparing to speak the first words of her ruling. Her gaze swept the room, a final tacit assessment. It was in that sweep that her eyes caught a flicker of movement at the side door reserved for court personnel. A young deputy clerk, her face pale, entered with a haste that bordered on impropriety. She carried a single standard-issue federal case file, but it bore no case number, no label, just a simple, shocking blankness. The clerk hurried to the bench, whispered urgently to the judge's law clerk, who then, with a look of profound confusion, placed the unmarked file directly before Judge Vance. A ripple, subtle but electric, passed through the few observers in the gallery. Price's eyebrow twitched. Chun leaned forward, his exhaustion replaced by acute focus. Judge Vance did not open the file immediately. She stared at it as if it were an artifact from a different, more chaotic dimension that had intruded upon her sterile chamber. For a long, suspended moment, the only thing that moved was the dust motes dancing in the slants of light. Her poise, that famous composure, didn't break, it intensified. It was the calm of a reactor core right before containment. She slowly lowered the verdict notes she had prepared, placing them to the side with deliberate care. She then opened the plain file. Her eyes scanned the first page, then the second. A profound stillness settled over her features, a stillness so deep it was louder than any gasp. The color did not drain from her face so much as it was replaced by a marble-like intensity. The room's atmosphere changed. The sterile chill was now the cold of deep space. The hum of the HVAC system sounded suddenly like a held breath. She closed the file with a soft, definitive click. The sound echoed in the silence. When she looked up, her winter blue eyes were lasers, pinning first the defense table, then the prosecution. She did not look confused. She looked informed. "Counsel," she announced, and her voice, usually dry and measured, held a new flinty edge that cut through the quiet like a shard of glass. It was not a loud voice, but it carried to every corner, demanding absolute fealty. "The court must apologize for the interruption. It appears there has been a significant, and I dare say deliberate, obstruction of the judicial process." She let that phrase hang, obstruction of the judicial process, a federal crime in itself, poisoning the well of the entire trial. "A piece of evidence," she continued, her words precise and chilling, "has just been delivered to this bench. Evidence which, according to the source who provided it to the clerk's office, was subpoenaed in good time by the prosecution, was reported as non-existent by the responding entity, and was subsequently buried within a proprietary data archive it had no legal right to shield. This evidence was not lost. It was hidden." At the defense table, Clayton Price's serenity shattered. "Your Honor, I must object. This is highly irregular, a violation of procedure, we have no knowledge of." "You will have your opportunity, Mr. Price," Judge Vance interrupted, her tone leaving no room for debate. "But first, you will listen." This court was on the verge of rendering a verdict based on a record that has now been revealed to be critically incomplete. "This," she tapped the unmarked file with a single sharp finger, "is not a new witness. It is not a novel interpretation. It is a foundational dataset, the very digital bedrock the defendant swore under oath did not contain relevant communications. Its absence created the reasonable doubt your case so masterfully constructed." She turned her gaze to David Chun, who looked as if he'd been thrown a lifeline from an unknown ship. "Mr. Chun, the prosecution's discovery requests for the Project Hermes internal server logs were denied by Ether Dynamics on grounds of non-existence, correct?" "Yes, Your Honor," Chun said, his voice thick with a sudden fierce hope. "It appears," Judge Vance said, her voice dropping into a register of cold righteous fury, "that the server did exist. And that on it, this court has just been presented with a log of real-time encrypted messages between Mr. Thorne and the now-resigned CEO, explicitly discussing the fabrication of the very revenue projections this case hinges on. Dated, time-stamped, and untouched. The what-ifs and optimisms you have argued for 7 weeks, Mr. Price, are here in this file, presented as cold executable business orders." She paused, letting the magnitude of this sink in. The house of cards didn't just wobble, its foundation was shown to be pure air. The secret evidence wasn't a footnote, it was the entire suppressed narrative. Therefore, Judge Vance concluded, the finality in her voice shifting from verdict to inquisition, "I am delaying judgment. This court is now in receipt of what appears to be prima facie evidence of a fraud upon the court itself. This proceeding is no longer just about corporate fraud. It is about the integrity of this institution. And it has just taken a drastic and unforgivable turn." The bombshell had detonated not with a shout, but with the calm, devastating delivery of truth. The story of United States versus Ether Dynamics was over. A new, far more dangerous one had just begun. For a full 10 seconds after Judge Vance's pronouncement, the courtroom existed in a state of suspended animation. The bombshell had detonated in absolute silence, leaving behind a vacuum that was quickly filled with a low collective intake of breath. Then the digital world, so long held at bay by courtroom decorum, erupted. A symphony of muted buzzes and vibrations hummed from the press row and public gallery, like a swarm of mechanical insects coming to life. Thumbs flew across glass screens. A Reuters correspondent typed a one-word alert to her editor, "Earthquake." A blogger for a finance watchdog site began live-tweeting in a frantic staccato, "Vance halts Ether verdict. Secret data entered. Claims evidence buried. This is big." Thorne looked like he saw a ghost. Hashtag Ether fraud. The story was no longer a legal technicality, it was a live, breaking scandal. At the defense table, Clayton Price's mind was a war room under sudden siege. The serene tactician was gone, replaced by a field general reacting to an unseen artillery barrage. His first, instinctive move was one of procedural offense. "Your Honor," he said, his voice straining to reclaim its usual sonorous authority, "this is a travesty of due process. We have had no opportunity to examine this alleged evidence, to verify its authenticity, to challenge its chain of custody. This is trial by ambush, and it violates every tenet of the Fifth and Sixth Amendments." He spoke of amendments and tenets, but his eyes were wild with a more primal terror, control. The entire defense had been architected around the known discovery, the documents they had meticulously sanitized, the emails they had carefully phrased. A completely new dataset was the nightmare scenario. David Chun, meanwhile, was experiencing a jurisprudential whiplash. Moments ago, he was drafting in his mind the somber postmortem with the U.S. attorney. Now he was scrambling to comprehend the scale of the gift, or trap, that had just landed in his lap. "Your Honor," Chin responded, his voice steadying with the prosecutor's regained conviction, "the government, too, has just learned of this file. But if it contains the Project Hermes server logs our subpoena sought, logs the defendants categorically denied existed, then the obstruction is not by the prosecution, but against it. This goes to the very heart of the case's integrity." Judge Vance let the legal ping-pong volley once, then raised a hand. The gesture was like a guillotine falling. "The court is aware of the procedural gravity, Mr. Price. Which is why we are adjourning for 2 hours. During that time, the clerk will provide a secured digital copy of this evidence to both counsels under a strict confidentiality order. You will have a chance to examine it. But understand this, my initial review is not of a single document. It is of a narrative." She leaned forward, and her description of the evidence transformed it from an abstract bombshell into a living, breathing entity, a digital ghost. "The secret evidence," she intoned, "is not a dusty memo in a forgotten safe. It is a data trail. A buried stream of communication from a platform called Sentinel Secure, a supposedly discontinued internal messaging system Ether decommissioned over a year ago." She watched Thorne flinch at the product name. The logs show it was not decommissioned. It was hidden. Within it, under codenames auto-generated from classic novels, are real-time conversations between user Raskolnikov and user Bazarov that mirror, with chilling precision, the timestamps of keyboard meetings and press releases. Chen was scribbling furiously. Price had gone very still. "These are not speculative what-ifs," Judge Vance continued. "They are instructions." On April 14th, the day before the Q1 earnings call, Raskolnikov writes, "Solar yield projections from Nevada are 40% under model. Need the phantom carbon offset tally activated to bridge gap. Use the Singapore shell. Bazarov, confirm by end of day." Bazarov replies, "Package deployed. Audit trail points to legacy accounting error. Will bury in the Hermes archive." She let the translated code hang in the air. Phantom tally. Singapore shell. Bury in the Hermes archive. This was the language of fraud, stripped of its corporate jargon. The Hermes archive, Judge Vance clarified, is the very cloud server your client, Mr. Price, stated under oath was a theoretical IT construct, and held no business data. This data trail shows not just the creation of false numbers, but the conscious creation of a false reality to explain them away. It shows the editing of financial logs, with metadata intact showing the original, accurate numbers before they were altered. It is a ledger of the lie. The damning picture was now clear to everyone in the room. This was not about mid-level accountants making bad guesses. This was a coordinated, C-suite directed cover-up. The rogue employees theory was incinerated on the spot. The messages reached up, implicating the resigned CEO, and painted Michael Thorne not as a negligent CFO, but as an active architect of the deception. "This evidence," Judge Vance concluded, her voice cold, "is a digital ghost. It is the preserved echo of conversations its participants believed were erased, transmitted through servers they swore were empty. It proves the defense narrative, of good faith error and isolated misunderstandings, was itself a meticulously crafted lie. Mr. Price, you will now have 2 hours with this ghost. I suggest you and your client prepare to address its very substantial allegations. Court is in recess." The gavel cracked. The spell broke into a cacophony of scrambling. Price immediately huddled with Thorne, their whispers fierce and panicked. Who had access? Who talked? Thorne hissed, his earlier smugness replaced by a sheen of cold sweat. Reporters bolted for the marble hallway, phones pressed to ears, shouting to cameras about smoking guns and digital cover-ups. In a secure annex, a government IT specialist, brought in by the clerk, used a hardware-encrypted drive to copy the files for both legal teams. The data, this digital ghost, was no longer a secret. It was now the center of the universe, its cold binary truth ready to dismantle every fiction constructed in the warm wood-paneled room. The trial was no longer about guilt or innocence of fraud. It had morphed into something darker, a trial of the truth itself, and the lengths to which powerful men would go to murder and bury it. The 2-hour recess stretched into 2 days, then 2 weeks, as the sterile federal courtroom gave way to the chaotic, sprawling theater of a national scandal. The unmarked file was not just evidence, it was a key that unlocked a digital Pandora's box. Judge Vance's delay of the ruling was not a pause, it was a detonation, the shockwaves of which radiated out from her bench to the halls of the Justice Department, the glass towers of Wall Street, and the endless churn of the 24-hour news cycle. Within the Department of Justice, the mood shifted from defensive to aggressively offensive. The Public Integrity and Securities Fraud sections, now collaborating in a dedicated task force, tore into the Sentinel secure data with the fervor of archaeologists decoding a lost language. The digital ghost was not a solitary specter, it led to others. Raskolnikov and Bazarov were just the start. The logs contained routing codes that pointed to offshore servers in Singapore and the Cayman Islands, the very shells mentioned in the messages. Subpoenas, backed by the newfound judicial fury of Judge Vance, who labeled Ether's actions a fraud upon the court, flew to tech companies, financial institutions, and audit firms. The original case against Michael Thorne was now a footnote. The new indictments came down like a hammer. The resigned CEO, arrested at his Montana ranch, Ether's general counsel, for conspiracy to obstruct justice, and 3 top-tier partners at the prestigious auditing firm Sterling & Vail, for willful blindness and evidence tampering. The narrative was no longer about one company's fraud, but about the ecosystem that enabled it. The media storm was instantaneous and all-consuming. Cable news split screens featured Clayton Price's stony silence outside the courthouse opposite legal pundits breathlessly dissecting the meaning of digital ghost. The term itself went viral, becoming a hashtag and a shorthand for corporate corruption in the digital age. On financial networks, tickers scrolled with volatile Ether stock prices, now a penny stock, as analysts connected the Singapore shell to other, seemingly robust tech darlings, causing sector-wide tremors. Op-eds declared it the Vance principle, the notion that in an era of digital illusion, the judicial system's most vital role might be that of a forensic data recovery firm. Twitter was a wildfire of speculation, memes of sinking corporate logos, and triumphant threads from the niche tech bloggers who had doubted Ether's green miracle all along. Inside the courtroom, when proceedings finally resumed, the atmosphere was transformed. The polished confidence of the defense was sanded away, replaced by a brittle technical desperation. Price no longer argued the merits of the projections. He fought a rearguard action against the evidence itself, a fruit of the poison tree, he argued, claiming the data was obtained through a procedural breach. He hired a celebrity digital forensics expert to suggest, with impressive but vague jargon, that the logs could have been spoofed or tampered with post-collection. It was a strategy of throwing sand in the gears, of trying to transform a clear story into an unknowable mystery. But Judge Vance and David Chun were prepared. The prosecution had spent the intervening weeks building a gateway of verification around the digital ghost. They called the deputy clerk to testify about the chain of custody. The file had come from a confidential whistleblower within Ether's own IT department, a man now in witness protection, who had copied the data before the scheduled decommissioning of the Hermes archive. They called experts from the National Institute of Standards and Technology to explain the cryptographic signatures embedded in the Sentinel secure logs, signatures that were unique to Ether's registered software license and impossible to replicate after the fact. The data wasn't just a message, it was a sealed, self-authenticating digital artifact. Price's sand was met with a transparent blast of procedural and scientific rigor. The final day of arguments was not about guilt. It was about consequence. Chun, in his closing, stood before a quiet court and spoke not of numbers, but of shadows. This case began as an investigation into financial fraud, he said, his voice low and firm. But it revealed a more profound crime, the attempt to delete reality. They didn't just lie about numbers. They built a digital tomb, walled up the truth, and swore to this court that the tomb was empty. They believed their fortress was impenetrable. They believed their word, as powerful men, would be the final record. He turned and pointed not at Thorne, but at the sleek, silent laptop on which the evidence was displayed. But the truth, once uploaded, never truly disappears. It lingers. It waits in a bit of forgotten server space. It whispers to a conscience. It finds its way, through cracks and courage, into the light. That is the new verdict of our age. When Judge Eleanor Vance finally delivered her ruling, it was 92 pages long. It found Michael Thorne guilty on all counts of securities fraud, wire fraud, and conspiracy. But the most searing passages were not the verdicts themselves. They were the findings of fact, a cold judicial evisceration of the cover-up. She wrote, "The defense was not merely wrong in its interpretation of events, it was architecturally dependent on a deleted truth. The digital ghost is not spectral, it is the most solid evidence this court has encountered, for it is the unvarnished contemporaneous record of criminal intent, preserved by the very technology employed to conceal it." She sentenced Thorne to 22 years in a medium security prison, a term that sent a visible shudder through the white-collar defense bar. The final gavel's crack was not an end, but a resonance. The echo traveled. In corner offices across the country, in-house counsel hastily convened meetings to audit discontinued systems and re-evaluate data retention policies. On Wall Street, a new due diligence question entered the lexicon: where is your Hermes archive? The real verdict was a cultural and technological warning. It signaled that in today's America, the digital fortresses of power, the encrypted chats, the buried servers, the algorithmic smoke, could be breached not only by hackers, but by a slip of conscience, a flawed IT policy, or the unwavering demand of a judge who understood that data is the new testimony. The story of United States versus Ether Dynamics concluded not with the closure of a case file, but with the opening of an era. The precedent was set. The past, especially the digital past, was no longer a country that could be erased. It was a witness, waiting to be called. Thanks for watching. Please don't forget to like, share and subscribe for more stories from Courtroom Drama.